Perfect. I will resume the recording.
Recording in progress.
This court is now resumed. Thank you.
Good afternoon, everyone. We're at the the stage of things where we're going to be hearing from the Assembly of First Nations, and before we do that, just want to make sure. So the Chiefs of Ontario, you're ready to proceed after the AFN. We could take a break for 5 minutes just to before we turn it over to you. Is that acceptable?
Yes, that's acceptable, Justice.
Thank you. And Nan, I think we could probably begin tomorrow with your submissions, but I want to address, I just saw the message in the course of taking notes. I noticed that there was a chat message about spotty internet connections. Were you able to resolve that? Like, is that, everything
yes,
is
Your
good?
Honor.
With,
it seems like it's now okay.
Okay.
And my submissions are actually going to be quite brief. So I'm prepared to go ahead today as well.
Okay. In that case, we will add Nan as well as this Chiefs of Ontario to we'll break, of course, after the AFN, and just to give everybody a breather. So thank you for that, and I hope the connection remains well. If you've missed any part of the proceedings, just let the court know, and we'll see what we're able to
If
provide.
I may intervene, if there's any connection issues, Your Honor, anyone can reach me. You can contact me as well. I will try to expedite that with the video conference specialist.
Okay. Perfect. Okay, with those housekeeping matters out of the way, I'll turn it to the Assembly of First Nations, and I'm not sure who's taking the lead today, but I'll let you decide who's going to be submitting.
Good afternoon, Justice Fable. Stuart Wetke for the Assembly of First Nations. Stuart Wetke, General Counsel with AFN. Before we get started, I want to acknowledge that I'm here in Rama First Nation with my colleague, Mr. Naogabo. I want to acknowledge that I'm located in the Williams Treaty Territory and home to the Chippewas of the Rama First Nation. And once again, I would like to acknowledge the opening by Elder Sakani. And of course, our thoughts go out to the Kamloops First Nations and all First Nation survivors across Canada regarding the deceased children. So this matter concerns a request by the Attorney General of Canada for judicial review by this court of a series of decisions of the Canadian Human Rights Tribunal, which I'll refer to as a tribunal, regarding the criteria for determining eligibility under Jordan's principle rendered in its July 17th and July 17, 2020 and November 25th, 2020 decision. More broadly, the 2020 CHRT 20 as well as 2020 CHRT 36. Now, the AFN adopts our previous, I should say, the AFN adopts for the purposes of this application our oral submissions we made in the standard review and the applicable principles, as well as the review of the procedural history. They even notes that the tribunal found that First Nation children are being denied access to services and supports by Canada's restrictive definition of Jordan's principle. In fact, prior to 2016, not one Jordan's principle application was approved by Canada. In a series of decisions, the tribunal had been critical of Canada's half-hearted attempts to implement the orders of the tribunal regarding Jordan's principle. In fact, it was Canada's non-compliance with the directions of the tribunal which ultimately resulted in a need for the tribunal to impose a definition of Jordan's principle on Canada. This judicial review is another blatant attempt to avoid the provisions of medical and social services to First Nation children, to which they are both entitled to and required through narrow application of Jordan's principle. In a twist of irony, Canada takes exception to the fact that the Canadian Human Rights Tribunal would not endorse or sanction Canada's attempt to limit the effect of Jordan's principles to the detriment of First Nations children through the application of racist law, namely the Indian Act. Canada's past practices, which have ultimately resulted in denying and delaying of services, has resulted in significant harms to many First Nations children, and tragically, sometimes their deaths. The Wikipedia situation is a clear example of how Canada's callous indifference to the plight of vulnerable First Nations children, based on funding considerations and the narrowed interpretation of Jordan's principle, contributed to the adverse outcomes for First Nation children, in this case, multiple suicides. And that was discussed by the tribunal in its decision of 2017, CHRT 7. Once again, Canada seeks to put its own financial interests above those of First Nations children and family, which the tribunal notably condemned in its merits decision back in 2016. The AFN is of the view that the orders of the tribunal regarding eligibility of Jordan's principle was reasonable and must be upheld. Furthermore, the tribunal is entitled to deference when it crafts remedies under subsection 53(2)A and C of the Canadian Human Rights Act. The AFN respectfully submits that this court dismiss Canada's judicial reviews in its entirety. Before I go much further, I want to provide you with the roadmap, what I'll be saying in our submissions. First, I'm going to start with some additional submissions on the standard of review and the principles that ought to be applied by this court in this judicial review. Next, I will review on the history of these proceedings relating to Jordan's principles and the tribunal's decision on eligibility. Thirdly, I'll provide the court with some focus submissions which address the following issues: the divergence between status, I should say Indian status, and First Nation citizenship. Secondly, the decision to extend eligibility to off-reserve First Nation citizens was reasonable. Thirdly, the tribunal's reasonable, practical, and pragmatic approach to eligibility Jordan's principles and related services. And I may provide, providing if I have time, some responses to Canada's submissions. Now, with respect to the standard review, in this application for judicial review, Canada wrongly asserts the tribunal's reasoning on eligibility for Jordan's principles lacks justification, intelligibility, and transparency. The AFN submits that the tribunal's reasons are detailed, cogent, and rational. This court should refrain from interfering with the tribunal's reasons. Under the Vavilov framework, reasonableness is a robust form of review, requiring the reviewing court to examine whether both the outcome and the reasoning justifying the outcome was reasonable. At paragraph 84 of the Vavilov decision, it states that a principled approach to reasonableness review is one with which there's those reasons first. A reviewing court must begin its inquiry into the reasonableness of a decision by examining the reasons provided with respectful attention and seeking to understand the reasoning process followed by the decision maker. At paragraph 85, court must assess whether the decision as a whole is reasonable. A reasonable decision is one that's based on entirely coherent and rational chain of analysis that is justified in relation to the facts and law, that is constrained in the decision maker. Or that is to constrain the decision maker. The reasonableness standard requires that a reviewing court defer to such a decision. Paragraph 86, reasonableness, according to Dunsmuir, is concerned mostly with the existence of the justification of transparency and intelligibility within the decision-making process, as well with the decision whether the decision falls within a range of possible acceptable outcomes which are defensible with respect to the facts and law. At paragraph 91, the reviewing court must bear in mind the written reasons given by the administrative body, which must not be assessed against the standard of perfection. That the reasons must given for a decision do not include all arguments, statutory provisions, jurisprudence, or other details the reviewing judge would have preferred. And in paragraph 92, the administrative decision makers cannot always be expected to deploy the same array of legal techniques that might be expected of a lawyer or a judge, nor will it be necessary or even useful for them to do so. Further, as noted by the Federal Court of Appeal in Zales, where the evidence before the administrative decision maker permits a number of outcomes, the administrative decision maker draws upon the expertise, such as knowledge, experience, and familiarity of the tribunal hearing. And there is relatively little in the way of constraining legislative language, such as the CHRA. The administrative decision maker will have a large permissible space for acceptable decision making. And that's in the oral compendium, paragraph 79, base numbering, page 397. Now, with respect to the facts, I'll go through some of the facts leading up to the decision on eligibility. And of course, it starts out with the merits decision, which my friends from the Caring Society pointed out to this morning. And it's in the joint electronic record at tab 131. In the merits decision, the tribunal found that Canada's definition and implementation of Jordan's principle was inadequate and excessively narrow. This resulted in discriminatory service gaps, delays, denials, and services for First Nation children. And you can find those references at paragraphs 381, 391, and 458. The tribunal found that Canada's approach to Jordan's principal cases was aimed solely at intergovernmental disputes between the federal and provincial governments and situations where a child had multiple disabilities. Canada was also ordered to cease applying a narrow definition of Jordan's principle and to take measures to immediately implement the full meaning and scope of Jordan's principle. That's at paragraph 481. In a following decision, 2016 CHRT 10, roughly 3 months after the merits decision, INAC and Health Canada indicated that they began internal discussions on the process for expanding the definition of Jordan's principle. Canada sought to identify other partners who would be involved in this process. They anticipated it would take about 12 months to engage with First Nations, provinces, and territories in these discussions to develop options to change the Jordan principle. The tribunal took exception to Canada's proposal, stating that its order was to immediately implement the full meaning and scope of Jordan's principle. Canada's proposed focus to start discussions on the review of the definition was not consistent with the tribunal's orders. Canada was ordered to immediately consider Jordan's principle as including all jurisdictional disputes, including disputes between the federal government departments and involving First Nations children, not only those children with multiple disabilities. In 2017 CHRT 14, another decision rendered in May of 2014, the panel stated that Canada's definition of Jordan's principles did not fully address the findings in the merits decision and was not sufficiently responsive to the previous orders of the panel. While Canada had expanded its application of Jordan's principle, it had nevertheless continued a narrow application of Jordan's principle to certain First Nations children. INAC restricted the application of the principle to First Nations children on reserve with disabilities and those present with a discrete short-term issue for which there was a critical need for health and social supports. The tribunal confirmed that this narrow definition was not in compliance with the previous order and that Canada continued to narrow the application of Jordan's principle to certain First Nations children. In expressing its frustration with Canada's non-compliance, the tribunal stated, reform was ordered. However, based on the evidence presented in this motion regarding Jordan's principle, Canada seems to want to continue offering similar services and practices to those that were found to be discriminatory. Any new programs, policies, practices, or funding implemented by Canada should be informed by previous shortfalls and should not be simply an expansion of previous practices that did not work and resulted in discrimination. They should be meaningful and effective in redressing and preventing discrimination. The tribunal further noted that Canada's narrow interpretation of Jordan's principle, coupled with its lack of coordination amongst its programs, along with emphasis on existing policies and avoiding potential high costs of services, was not the approach that was required to remedy discrimination. Rather, decisions should be made in the best interest of a child. The tribunal's May 26, 2017 order required Canada to base its definition and application of Jordan's principle on key principles, one of which was Jordan's principle as a child-first principle that applies equally to all First Nations children, whether they live on or off reserve. That's found at paragraph 135 of that decision. As noted by the tribunal in decision at issue, Canada challenged some aspects of 2017 CHRT 14, ruling by way of judicial review, which was subsequently discontinued following a consent order from the tribunal, essentially amending on the consent some of the parties' aspects of the order pertaining to timelines, critical case conferencing and structures. I won't go into it, but essentially it's paragraphs 15 of that decision. With respect to the next decision, 2017 CHRT 35, in 2017, the tribunal amended its orders to reflect some wording changes suggested by the parties. And there's a big long list of changes that is requested, that the parties requested. That's in the decision. I won't go through them, but it's basically essentially starts at section B of that decision. It's quite a lengthy portion of the decision. In 2019, CHRT 17, so in 2019, there was a disagreement over what constituted a First Nation child for the purpose of the tribunal's orders relating to the provision of Jordan's principle. The panel determined that this issue of a First Nation child definition would be best addressed by way of a full hearing. The panel chair requested the parties to make arguments on international law, including the United Nations Declaration on the Rights of Indigenous Peoples, recent UN Human Rights Committee's McIver decision findings that sex-based discrimination continues in the Indian Act, also Aboriginal law, human rights, and substantive equality and constitutional law and other aspects. The panel notes that Canada's registration requirements as per the Indian Act have a direct correlation with whom receives services under Jordan's principle and therefore support the importance of a full hearing on the issue. I would like to point that out because it speaks to somewhat of Canada's procedural fairness issues. Rather than dealing with this matter by way of a written record, Canada did give the parties the opportunity to have a hearing on this matter, provide submissions, affidavits, and other introduce evidence into this. Nevertheless, the tribunal provided the following interim relief. At paragraph 89, the order applies to First Nations children. So Jordan's principle would apply to First Nations children without Indian Act status who live on reserve but are recognized by members of the First Nation. Sorry, that's what the discussion is about. And secondly, we have urgent and life-threatening needs, and evaluating urgent life-threatening needs due to consideration must be given to seriousness of the child's condition, evaluation of the child aid. And my friend from the Caring Society went through that earlier today. Moving on to the current decision under review, 2020 CHRT 20. The tribunal found that Canada's approach to Jordan's principle focused on Indian status or eligibility for status. Under this approach, Canada would exclude non-status First Nation children living off reserve from accessing Jordan's principal services. The tribunal noted that its earlier findings, including the effects of First Nation children of intergenerational trauma from residential schools and disruptions to identity from moving off reserve, required more than a pecuniary redress. And that's at paragraph 111, I should say. The tribunal confirmed that the following categories in use at the time by Canada are appropriately considered to be First Nation children for the purposes of Jordan's principle. And the tribunal listed 4 criteria Jordan's principle will apply to. They include First Nations children registered under the Indian Act, living on or off reserve. First Nation children eligible to be registered under the Indian Act, living on and off reserve. Non-status First Nation children without the Indian Act status who are ordinarily resident on reserve. And fourthly, First Nation children without Indian Act status who live off reserve but are recognized by members of their nation and who have urgent or life-threatening needs. Noting that First Nations children without Indian status may face many of the same barriers as on-reserve children, the tribunal expanded eligibility for Jordan's principle to children that, number one, are recognized by the First Nations for the purposes of Jordan's principle eligibility and have one parent registered or eligible for registration under 6.2 of the Indian Act. Rather than dismissing claims outright, the tribunal stated that Canada should take a case-by-case approach in letting such children through the door, as my friends pointed out earlier. And then from there, assessing whether the actual provision of services would be consistent with substantive equality principles. Such a substantive equality lens would allow for service providers to focus on the First Nations child's specific needs, which includes consideration of any intergenerational trauma, other forms of discrimination, and historical disadvantage they may face. Pursuant to Section 53.2 of the CHRA, the AFN, the Caring Society, and the Commission, COO, NAN, and Canada were ordered to consult with each other in order to generate potential eligibility criteria for First Nations under Jordan's principle, and establish a mechanism to identify citizens or members of First Nations that is timely, effective, and considers implementation concerns by all parties. Canada was to immediately consider eligible for Jordan's principle services those children who become eligible for Indian Act registration under Bill S3 implementation, being a bill who would basically broaden status under the Indian Act. Now moving on to the final decision, I'll be speaking to 2020 CHRT 36. Pursuant to the tribunal's instructions, the parties developed a proposed framework to enable children to receive services through Jordan's principle. The CHRT rules that cases meeting any one of the 4 criteria are eligible for Jordan's principle. The criteria includes, again, much similar before, a child that is registered or eligible for Indian status under the Indian Act as men from time to time. The child has one parent who is registered or eligible to be registered in the Indian Act. A child is recognized by the First Nation for the purpose of Jordan's principle. And finally, a child is ordinarily resident on reserve. The provisions establish a default process to confirm eligibility that is intended to facilitate substantive equality of First Nations children. Individual First Nations and provincial territories are able to agree to a different process under the framework that was developed by the parties. Potential Jordan's principle applicants relying on the criteria of recognizing by the First Nation may obtain confirmation from the First Nation through the appropriate individual or provide Indigenous services consent to seek the confirmation on their behalf. The process provides confirmation of recognition to facilitate confirmation. And finally, of course, for urgent cases relying on recognition by First Nation, a verbal confirmation is available. This also applies to cases where the designated official might not be able for contact. It provides a default that the child will receive urgent assistance to address any reasonable foreseeable risk of harm. Requests made to children in life or end of life or palliative care are considered urgent. And this was a framework that was developed and it was largely suggested by the AFN at the outset in the hearing, but essentially recognizing that First Nations are the most appropriate authority to determine who their citizens are, and a simple verification call or something to the First Nation to a designated individual may provide that recognition so the services can be provided. I'll be moving on to my submissions. In a sense, in Jordan's principal eligibility decision 2020 CHRT 20, the tribunal conducted a thorough analysis of the circumstances of First Nation children and the history of Canada's racist policy of enfranchisement. The question before the tribunal raised important questions about the appropriate interpretation and meaning of First Nations children for the purposes of Jordan's principle. The argument that Indian status was a determinative factor for eligibility includes a presumption that only applies to those individuals who Canada recognizes as Indians, which is incoherent, is incorrect and not grounded in law. In determining whether eligibility is solely restricted to status Indians, the tribunal focused its analysis on a collection of case law involving Vanderpeet, Sioux, Delgamulla Haida Nation, Amajon, Simon, Vanderpeet, etc., which are all cases of the Supreme Court of Canada that determined reconciliation of pre-existence of Aboriginal societies in North America necessitated an examination of practices, customs, and traditions of historical collective when defining Aboriginal rights. There have been several reports and commissions of inquiry which have examined the complex histories of First Nations, as well as First Nations societal structures, beliefs, and laws. Most notable, the Royal Commission of Aboriginal Peoples detailed the history of First Nations and recognized the diversity among First Nations belief, laws, and relationships prior to contact with settlers. First Nations perspectives on law, as well as their social and political organizations prior to contact with settlers, is integral to the understanding of First Nations and their inherent right to jurisdiction over membership and citizenship. The rights of a nation which existed since time immemorial and prior to contact with the settler state cannot be subsequently defined or unilaterally infringed upon by another nation. As Professor John Burroughs states, courts have always noted that First Nations have their own systems of law, and that great care must be exercised when translating the law into common law. The panel reflected upon this type of case law, the UN Declaration on the Rights of Indigenous Peoples, the Royal Commission on Aboriginal Peoples, as well as the positions of the parties in coming to a determination on the issues before it. The panel analyzed every argument made to it from the viewpoint of determining the appropriate remedy within a broad remedial discretion that it was afforded under the Act in order to remedy discrimination First Nation families encountered and the discriminatory conduct of Canada as established within its merits decision. Notably, Canada did not contest the said findings in any way. After several written and oral submissions, the tribunal addressed eligibility access to Jordan's principle reasonably with careful attention to its home statutes, human rights standards, both domestic and international. The tribunal turned to its statutory authority and it relied on well-established principles that apply to it, and any review of eligibility decision must respect those principles. At paragraph 135, the tribunal referred to the principle that the Human Rights Act is quasi-constitutional legislation, which means remedial powers are to be interpreted in a broad and liberal manner, and limitations or exceptions are to be interpreted narrowly. Now, I'd like to speak to the divergence between Indian status and First Nation citizenship.
Mr. Watkins, before you do that, just I think it's timely. It's a good question at this point. You indicated that you were going to try to respond to the Attorney General's points later. I'll give you an opportunity now because I think it's topical. Mr. Frater mentioned that Canada isn't compelled, according to my notes, I may have not captured it 100%, but Canada is not compelled to ignore the Indian Act. So you have that position, and then you have the position that you've just outlined. You know, the UN Declaration, you've got RCAP, much of the case law that you've identified. So there's definitely a clash. So what should be done in light of this very divergent position in terms of this legislation called the Indian Act?
Well, our position, of course, is that Canada's reliance on the Indian Act and saying it can't ignore the law is really a policy choice. And it's a policy the choice are making, and really, there is nothing in law that requires them to do that. As my friend from the Caring Society pointed out earlier, when Parliament passed its motion on the Jordan's principle, clearly it did not say anything about the requirement of Indian status. And likewise, when Canada recently amended its policy to include non-status individuals living on reserve, making it residency-based, again, Canada has made a policy choice that Indian Act status is even not applicable anymore. So the AFN would argue that Canada sort of answered this question on its own, recognizing that Indian status is not a predetermination to Jordan's principle. It's not required, and it can be different policy decisions can be made. So that's the first aspect. But I think that the tribunal was correct in looking at those policy choices and questioning their efficacy in remedying the discrimination. And rather than attack the Indian Act, essentially it looked at various options that were available for the tribunal to look at, and essentially made a decision that saying that Canada's policy choice perhaps should be revisited because they're not appropriate in these circumstances. And the AFN would agree with that.
Just to follow up, sorry to interrupt again. Thanks for the clarification. So is this where the the process, that was developed or recommended to be developed, just in terms of the parties sitting together and working with developing I think there was I can't remember if it's called a framework, but definitely I think the word process was used to assist how people could be identified. Is that where this comes from? That rather than dismiss and say we're quashing, which was not the issue, quashing the Indian Act, but to say, okay, well, we can find a practical way to figure this out, and that's the process. Is that a fair characterization?
That would be a fair characterization of what took place. Clearly, we had directions from the tribunal saying we want to implement this, and the better approach to providing Jordan's principle was to look at recognition that First Nations have of their own citizens. Even the government of Canada and Mr. Bennett, in discussing Bill S3, indicated that government wants to get out of the business of determining who is a First Nation person. So that'll eventually come in the future. But the process we developed was to respond exactly to that. You have these individuals, many of them have ties to their First Nation communities, and we set up a practical and pragmatic process where the government of Canada, in assessing Jordan's principle applications, could easily call up a designated person in a First Nation community and inquire whether or not that individual is in fact a member of that First Nation or a citizen of that First Nation. That provides a really, not a very burdensome process. It's not a very high bar to meet. There may be urgent cases, which we spoke to in the framework itself, where something may have happened during the evening and urgent need is required, in which case you can actually phone the First Nation rather than getting something in writing. So there are processes that the parties turn their mind to, which are, again, very pragmatic, practical, and provide good utility for moving forward on these bases.
Thank you. Sorry to interrupt the flow of your presentation.
That's okay. So moving on to the divergence between Indian status and First Nation citizenship. So the panel recognized in its ruling that there's a significant difference between determining who is a First Nation child as a citizen of a First Nation and determining who is a First Nation child entitled to receive Jordan's principles services, and what's the appropriate eligibility criteria to use in the latter. The tribunal found that various domestic and international legal instruments support the inherent right of self-determination of First Nations to identify their citizens and members outside the narrow lens of the Indian Act. In particular, this approach is consistent with protecting First Nations individual and collective and human rights as articulated in the United Nations Declaration on the Rights of Indigenous Peoples and other relevant international instruments, also Section 35 of the Constitution Act and the quasi-constitutional status of the Canadian Human Rights Act. Now, First Nation laws have always been a foundation for our relationships with one another and within our nations. These rights were practiced throughout history and are still practiced to the present day, regardless of the many ways the Crown sought to minimize and restrict First Nation rights. First Nations rights are not subject to the discretion of the Crown. They are not granted or permitted by the Crown. They pre-existed the creation of the Canadian state and will not be defined, narrowed, or unilaterally infringed upon to suit the policy objectives of the Crown. First Nations perspectives is the only perspective which is relevant to the determination of who holds First Nation rights. In determining whether Jordan's principle applies to First Nations peoples who are not resident in or citizens of a First Nation, the tribunal was correct when in its analysis of Vanderpeet, Haida Nation, Sui, and other decisions, which focused on the reconciliation of pre-existence of First Nation societies in North America. The AFN agrees with the tribunal's findings that it is wholly appropriate for Canada to propose a presumption or a threshold that to be met with regard to eligibility based on Indian status and residency reserves. Those were inappropriate, which the tribunal noted. The First Nation citizenship is not determined by the Indian Act. You're very clear about that. Concepts of status, the double mother rule, the second generation cutoff, which my friend spoke to, are not founded in First Nations laws. They are not representative of First Nations perspectives on our traditional territories, or our political structures, or societal norms, or values, or kinship. The tribunal's rejection of the Indian Act status provisions, which noted were rooted in Canada's racist and colonial policies and laws, was reasonably justified. Indeed, the tribunal noted that the Indian Act was designed to assimilate First Nations peoples and does not reflect First Nations definitions of themselves as nations. As properly noted, the tribunal in its decision stated at paragraph 102, the use of the expression all First Nations children used in the tribunal's rulings and according to the evidence before the tribunal was not based on the criterion rooted in the Indian Act. None of the parties, I should say, none of the panel's rulings focused on the Indian Act or status registration under the Indian Act, as demonstrated by the merit decision and subsequent rulings. The panel understands and considers the historical context and its connection to the discrimination found in the case, which also triggers orders to provide culturally appropriate services. This context transcends the Indian Act and its colonial perspective on First Nations governments. Now, the APTN would say, despite the racist and assimilative nature of these colonial policies, it remains clear that Canada's position in the context of administering Jordan's principle remained grounded in the same and associated existing funding regime, so it was callously disregarded First Nations children for so long. As noted in paragraph 73 of the decision at issue, Canada was clear that the tribunal's orders that Jordan's principle applies equally to First Nation children on or off reserve. Canada continued to submit that said statement must be understood in the context of Canada's funding regime rather than every child in Canada who identifies as First Nations. Canada continues to submit that this definition is not discriminatory despite being grounded in these racist colonial policies in relation to Indian status registration. And you can find that reference in the Attorney General's factum at paragraph 147. Canada continues to ignore the fact that the matter at issue is not about those registered or broad considerations who identify as First Nations, but arriving at a definition solely for the purposes of Jordan's principle, which reflected the Human Rights Tribunal's mandate of ensuring that no child would be left behind. Further to its core principles that all individuals should have their needs accommodated without being hindered or prevented from doing so by discriminatory practices based on race, national, or ethnic origin. The definition had to also be taken into account the tribunal's broad remedial powers, which noted by the Supreme Court of Canada are interpreted to be interpreted liberally and broadly, particularly in light of the tribunal's quasi-constitutional nature. Again, we quote a number of cases, Action Dry and Oral Compendium, Robichaud at tab 59 and at tab 29. So Canada's focus on residency with respect to eligibility and Jordan's principle for those who do not possess Indian status is yet another example of Canada's perpetuation of these discriminatory and racist policies grounded in the Indian Act. It is effectively another veiled attempt to narrow the application of Jordan's principle. This is best exemplified by Canada's argument that coverage for Indigenous children living off reserve who do not have Indian status recognizes that most federal programs are residency-based and that failing to cover these individuals could cause a gap in coverage. The AGC continues to take this colonial position with respect to residency. The tribunal in this case correctly determined that such an analysis would ignore the reality that throughout history of Canada, First Nations were forced from their territories, often displaced by the Crown for a variety of reasons, including the promotion of settlement and natural resource extraction. This was done in violation of First Nation law, common law, and the treaties which the Crown entered into with First Nations. The Crown should not be permitted now to benefit from the violation of its own laws. For reconciliation to be meaningful, the truth regarding the effects of Canadian laws and policies which forcibly removed First Nation and relocated First Nation women and children from their lands must be acknowledged. The tribunal rejected Canada's argument that non-status individuals living off reserve is outside the complaint. This argument is nothing more than an attempt to narrow the scope of Jordan's principles and limit Canada's financial obligations to those individuals that Canada recognizes, predicated on its racist and colonial policies. This position ignores First Nations perspectives, the realities of colonization, and does little towards achieving ultimate goal of reconciliation. The tribunal rightly noted that such an interpretation would result in yet another legal barrier for a group of First Nation individuals and perpetuate historic disadvantages of those individuals who are enfranchised under the racist provisions of the Indian Act. Furthermore, the Canadian domestic law is not singular authority on First Nations rights. International law is equally relevant. Both federal and provincial governments have explicitly endorsed international instruments that recognize First Nations self-determination and self-government. We also note that Bill C-15 regarding the codification of the UN Declaration has now gone through both the House and Senate and is awaiting royal proclamation. In particular, the United Nations Declaration recognizes the rights of First Nations peoples and the threats that they have experienced to these rights. Article 3 and 4 state that Indigenous peoples have a right to self-determination and to freely determine their political status and the right to autonomy or self-government in matters relating to their international and local affairs. At Article 33 of UNDRIP, it states that Indigenous peoples have the right to determine their own identity or membership in accordance with their customs and traditions. This expressly acknowledges the rights of First Nations to determine their citizenship and political representation. The UN Declaration helps define the responsibilities of governments in using international law as relevant and persuasive source of interpretation of domestic law, including the Canadian Constitution. Now, when the UNDRIP bill C-15 becomes law, that will be a federal statute equal to that of the Indian Act. So in rebutting Canada's argument that it's forced to look at Indian Act as a determinative factor, clearly that would run contrary to newly established legislation in Bill C-15. So there'd be two sources of federal law which the federal government can draw upon. As the ultimate goal of the honor of the Crown has been recognized as paving the way to reconciliation between the levels of government and First Nations, the APTN submits that the Tribunal's application of international human rights standards is reasonable. The UN Declaration on the Rights of Indigenous Peoples is a guide to the path of reconciliation. The Tribunal acted honorably in giving due effect to First Nations' inherent right to self-government and recognizing First Nation laws and jurisdiction to determine their citizenship. Its decision further aligned with the principles and properties transcended, let me repeat it. Its decision further aligned with its principles and properly transcended oppressive, racist, and colonial Indian Act considerations. In determination of who is a First Nation child for the purposes of Jordan's principle was reasonably and properly considered and ultimately respects the inherent rights of First Nations and self-determination, as well as international human rights instruments, as provided by the tribunal in the decision at issue. And paragraph 135 speaks to this. I don't want to take up too much time, so I won't get into it. But I would draw your attention to paragraph 135 of the decision. Now, moving on to the next part of our submissions, where we would like to speak to the decision to extend the eligibility of First Nations children not entitled to registration, but with a parent who has status is reasonable. So Canada alleges that tribunal ignored its jurisdiction by expanding eligibility to those children without Indian status, but with a parent who is registered or entitled to be registered is reasonable, as being unreasonable, and attempts to conflate the issue with considerations of band membership, alleging a conflict with those children recognized by First Nations via membership and those recognized further definition reached by the tribunal. Again, the Attorney General of Canada seeks to rely on and impose the Indian Act policies and norms. Ultimately, as addressed, the tribunal was cognizant of the First Nations' inherent right to self-determination, the right to determine their citizens. The tribunal also recognized there is a significant difference between determining who is a First Nations child as a citizen of a First Nation and determining who is eligible for Jordan's principle. It is clear that the decision was not intended to override or prejudice First Nations rights, but solely for the purpose of administering Jordan's principle. The tribunal ensured that First Nations could, if they so choose, identify their members or citizens for the purpose of eligibility, as exemplified in the modified eligibility criteria adopted by the tribunal. In paragraphs 41 essentially states that cases meeting one of the 4 criteria are eligible for consideration under Jordan's principle. The AGC alleges that the adoption of community recognition test by tribunal is unreasonable and exceeded its jurisdiction, citing the imposition of obligations on non-party First Nations. I spoke to this. It really provides an avenue for First Nations to identify who their citizens are. And draw your attention to paragraph 216 with respect to that 217. So despite Canada's assertion, the tribunal did not bind First Nations to participate, which it reasonably considered would exceed its jurisdiction, but reasonably directed Canada as a party to the proceedings provide First Nations with an opportunity to participate in identifying First Nations children for the purpose of Jordan's principle eligibility. And that is a pragmatic and practical approach to this issue. While funding is being considered, the tribunal solely identified it as a topic of discussion as a party's efforts to establish identification mechanism reasonable and develop in light of the process. Again, if you're going to ask First Nations to undertake a certain activity, it's only proper that you provide them with the funding to do that. And the tribunal, of course, reflected on the AFN submissions proposing that the First Nations be contacted with respect to identifying those children. And finally, on this point, the AFN would submit that tribunal's approach to those individuals recognized by a First Nation as a citizen, and where those children of a person of 6'2" status are eligible for Jordan's principal services is supported in rulings of the Supreme Court of Canada in the Desautels. In Desautels, paragraphs 24 and 86 of the decision, it states this, paragraph 24. The scope of Aboriginal peoples of Canada is clear. It must mean that modern-day successors of Aboriginal societies that occupy Canadian territories at the time of European contact. As a result, groups whose memberships are neither citizens nor residents of Canada can be Aboriginal peoples of Canada. At paragraph 86, in my view, the authoritative interpretation of section 35(1) of the Constitution Act is for the courts. It is for Aboriginal peoples, however, to define themselves and choose by what means to make their decisions in accordance with their own laws, customs, and practices. A clear blessing by the Supreme Court of Canada that First Nations determine who their citizenships are and determine their own internal processes. I'd like to move on to our final section that really deals with the decision to extend eligibility to offers of citizens as reasonable. Now, Canada has taken a position that all children living in a First Nation community, including those without Indian status, are eligible for services under Jordan's principles. This includes children ordinary residents on reserve. Canada's approach to eligibility relies heavily on Indian status and residency on reserve to support the proposition that federal programs are residency-based. This approach imports a geographic limitation to Jordan's principle, effectively disqualifying a segment of the First Nation population and membership from accessing services. Canada's approach would obscure and deny historical and continuing connections between individuals living off reserve and their First Nations. By attaching eligibility to a particular location with an artificially imposed boundary, such as a border of reserve, when an individual's traditional territories extend well beyond the current reservation land base, Canada is imposing a restrictive colonial concept of residency. This approach perpetuates government interference in one's attachment to the First Nations and further entrenches past injustices. The colonial history of dispossessing First Nations people of their land while restricting eligibility to programs and services to reserve boundaries should not become the basis for accessing services under Jordan's principle. Imposing geographical limitations to eligibility for Jordan's principle ignores that First Nations perspectives on family, community, and citizenship. It also perpetuates the realities of colonizations, which restricts fundamental freedoms of First Nations people within the land base. This is a process that runs counter to reconciliation and really is a reflection of a long gone past where First Nations were restricted to their own activities on reserve. The tribunal and many First Nations people have been displaced from the communities and families as a consequence of colonialism. These include residential schools, day schools, 60 scoops, and now child welfare. The AFN agrees with the tribunal that government policies of enfranchisement and assimilation created generations of displaced and culturally detached individuals that are First Nations. These individuals were often forcefully removed from their communities and stripped of their culture. They settled in urban centers, often partnering with non-First Nation individuals and producing children of mixed ancestry. Now, to exclude these individuals from access to services on Jordan's principle on the basis that they are not Indian enough, in quotes, this is not only offensive, but amounts to a return to the enfranchisement policies of the 20th century. The tribunal's decision to wreck Canada's position was reasonable, as these types of injustices not to be further entrenched by a human rights body. Canada's approach means that First Nation children without status and not resident in a First Nation community would have additional burdens to access needed medical and other social services. This approach is not coherent and perpetuates second-class membership within one's collective. In effect, it serves to diminish one's Aboriginal and treaty rights and undermines one's connection to the First Nation. The AFN respectfully submits that this court rejects Canada's enticement to validate Canada's approach to eligibility of Jordan's principle. Canada's approach would only serve to perpetuate historical injustices associated with enfranchisement and serves to undermine one's connection to their nation, extended families, and to their territories. In this vein, the tribunal stated in paragraph 263, furthermore, the panel finds that Canada uses its discretion to establish Indian Act registration or entitlement to Indian Act registration eligibility criteria to restrict access and therefore deny Jordan's principal services to First Nations children residing off reserve who do not have Indian status and who are not eligible for Indian status, but have a parent, guardian with, or with a parent who is eligible for Indian Act status. Relying on these discriminatory criteria, the Indian Act adversely differentiates between siblings and other family members because of the second generation cutoff rule that is meant to assimilate and remove First Nation citizenship. This amounts to discrimination and runs counter to what the panel is aiming to achieve in this case, namely to ensure Canada ceases its discriminatory practices and takes measure of redress for the practice to prevent same or similar practice from occurring in the future. Now, the tribunal found that an evidentiary and legal basis is that officers or children who do not have Indian status and who are not eligible for Indian Act status, but who have a parent with 6-2 status, share the same characteristics and have the same needs as other First Nation children eligible for Jordan's principal services. However, these children are denied the benefit of those services because of the Indian Act distinctions based in whole and part on a prohibited ground of race and ethnic origin. As my friends pointed out from the Caring Society earlier, no other group of children in Canada are subject to this restrictive legislative scheme. In short, a child with a parent who is registered under 6.2 of the Indian Act and with a parent with no status of eligibility, no eligibility status, will be treated differently than a child who has a parent who is registered under 6.1 of the Indian Act. My friends pointed out earlier this morning, even though Canada is sort of basing everything on this residency, Indian status assessment, the APTN would note that this paradigm is not universal across Canada. There are exceptions. For instance, First Nations with modern self-government agreements control their own membership. Those individuals without Indian status, but who are citizens of First Nations under these membership codes, are eligible for services under Jordan's principle, regardless of their residency. Keeping in mind the tribunal's retention of jurisdiction, which the court asked Canada earlier at paragraphs 118 and 119. It deals with Canada's, the panel's retention of jurisdiction at paragraph 118. In retaining jurisdiction, the panel is monitoring if Canada is remedying discrimination in a responsive and efficient way without repeating the patterns of the past. At paragraph 119, if past discriminations practices are not addressed in a meaningful fashion, the panel may deem it's necessary to make further orders. It would be unfair for the complainants, the commission, and the interested parties who were successful in this complaint after many years and different levels of court to have to file another complaint for the implementation of the tribunal's orders and reform the First Nation child welfare system. Now, keeping in mind Canada's argument that you're on reserve and have Indian status qualify for Jordan's principle, comparing that to self-governing First Nations where you don't have to have Indian status at all and can live anywhere in Canada and be eligible for Indian status. Really, this type of application would result in Jordan's principle applying to one group of citizens while denying the same privileges to other citizens of First Nations who fit the same type of comparator, for instance, the same type of blood quantum, you name it. These two groups would have the exact same characteristics, except that one would come from a self-governing First Nation, the other one doesn't. The AFN would submit that the tribunal was right in predicting that this type of scenario would result in more litigation in the future. It definitely opens up Jordan's principle to further litigation. This approach adopted by Canada would undoubtedly lead to further complaints before the tribunal, and the AFN would guess that the scope and frequency of such challenges may mirror those of sex-based discrimination under the Indian Act itself. The Caring Society noted that Canada has agreed to expand Jordan's principle to all kids, recognized by a First Nation. A large component of this order would be implemented regardless of this ruling. The AFN adopts the Caring Society submissions in this regard. So at this point, the Assembly First Nations say, it makes no practical sense to overturn or grant Canada's request. Basically, the tribunal has the ability to head off all these arguments, any potential future litigation of discrimination at this time. And that's exactly what it has done. It makes no sense to impose a legal scheme for Jordan's principle at this time when we know the UN declaration bills can become law. We know that Canada's current approach creates discrimination between various groups of people. This all can be addressed at this time by providing the relief that the tribunal has ordered, and that First Nations who recognize children as members of theirs or citizens of the community would alleviate all of that potential litigation. So the relief requested, the AFN respectfully requests that the Attorney General's application for judicial review be dismissed costs. In the alternative, should this Honorable Court determine that there is any deficiency in the process or reasons of the tribunal, the AFN would request and submits that the compensation, the eligibility decision should not be set aside, but rather affirmed, and any deficiencies identified be returned back to the panel for the appropriate with your appropriate directions to rectify. Now, the AFN submits, as we did earlier, that it would be inappropriate to remit this matter back to a differently constituted panel, as requested by the Attorney General of Canada, and secondly, that the panel's retention of jurisdiction over the last 9 years really has provided it with accumulated knowledge and insight management of this complaint. It'd be a waste of time if a new panel was ordered to look into this. Subject to any further questions, those are the submissions of the Assembly First Nations.
Thank you, Mr. White. Yeah, just have one. I think your colleague or your friend at the Caring Society answered this, but I'll give you an opportunity as well. The Attorney General argued that this would create a larger class for the compensation order. What's your position? I think your friend at the Caring Society mentioned that not for the willful and reckless, but possibly for the other the general compensation for pain and suffering. What's your position on that?
We completely agree with the Caring Society. I mean, the parties did turn their mind to this in developing the eligibility framework, and also the compensation framework. And we adopt their positions on this. Clearly, we turned our minds to it, and we developed that text in that compensation order to reflect the intentions of the party. I think they provide a full answer to that question.
One last question. Just Mr. Frater had mentioned earlier that the I think it was around paragraph 117 of the of this eligibility decision that the proceeding was about a non-compliance order, and the tribunal stated that it was not going to grant the order, but then they continued, and it's that continuation into these other areas was basically again, I'm going to paraphrase, which is dangerous, but just outside of its jurisdiction to keep going once the issue that was before it was basically determined. What's your position on that?
Well, our position on this, the motion itself raised an important issue regarding SJ and the thing, the circumstances of that individual. And, the AFN would agree with the tribunal that, we did not provide a definition of a First Nation child, and nobody asked that. So it would be a bit unfair to Canada to sort of say they were not complying with the tribunal's orders. But in addressing the question, clearly the Caring Society brought up issues with respect to the eligibility of Jordan's principle, and identified a segment of the First Nation population which continues to be denied services. And the Assembly of First Nations agreed with what some of the Caring Society was recommending. I don't think it's outside the complaint. I mean, clearly the tribunal was seized of the matter. And as the case evolves, I mean, this case has been going on for over 10 years, 20 years, really. It's been a long journey, and new issues have come up. The case has evolved, the issues have evolved. And with this in particular, I mean, the AFN was always of the view that First Nations determine who their citizens are. And when we read the orders in the past about a First Nation child being eligible for Jordan's principle, we just assumed that that would include all people of First Nations that are recognized. Keeping in mind, the tribunal did point out other individuals who were disenfranchised through Canada's racist past that may have lost a significant connection to their reserve or to their First Nation community. They are still ethnically from their nations, whether they're Cree, Oji Cree, Mi'kmaq. That shouldn't be a matter. The other thing the AFN would point out is that Canada's approach is inconsistent with many of the number of treaties and historical treaties Canada has entered into with First Nations. First Nations did not enter into treaties to bestow benefits on their status Indian descendants. The treaties were meant for their population at the time and all their descendants. It's Canada, again, through their policy and their racist legislation that has, impose this 6'1", 6'2" Indian status in First Nation communities. So Canada's approach, we would argue, is inconsistent with various aspects of Canadian law, including the number of treaties and the historical treaties, as well as the inherent right of First Nations to self-government. So we would state that that is completely within the scope of the tribunal to look at this issue. It was completely within the scope of the tribunal to look at various First Nations people who were impacted. And as my friend in the Caring Society pointed out, the Caring Society asked for more relief than the tribunal was willing to grant. And at that point, the Assembly of First Nations, of course, had some concerns with respect to going too far as well, especially with respect to people who self-identify. And the tribunal was live to that issue, and obviously provided those some discourse in its decision with respect to people who self-identify, just sort of narrowing and constricting who is actually a First Nation citizen, which I think was very helpful and provides reasonable parameters for Jordan's principle and the eligibility criteria to operate within.
Thank you for answering the question. I don't have anything further. So as promised, I think we'll take a short break before we roll into the submissions of the Chiefs of Ontario and Anishinaabe Ski Nation. So let's take a 10-minute recess, and we'll reconvene in 10 minutes. Thank you.
Perfect. This is well noted. The court is now in recess until 2:45. Thank you.
Recording stopped.
We are back from break. Mr. Justice Fable, do you want to do a round again for council just to make sure?
Yes, just to make sure. Thank you.
Perfect. You're welcome. Council, can you please advise that you are back from break recess, please? Thank you.
Yes, Canada is all back. Thank you.
Caring Society is back. Thank you.
Good afternoon. The Assembly First Nations is back.
Human Rights, pardon me. Yeah, Human Rights Commission is back. Thank you.
Nan is present.
Amnesty is here.
Congress of Aboriginal Peoples is here.
Sorry, Chiefs of Ontario is here.
All right, thank you. We are ready to hear submissions.
Recording in progress.
Oops. We're ready
Sorry,
to hear
sir.
submissions from Ms. Wente for the Chiefs of Ontario.
My name is Maggie Wente, and I'm here today on behalf of Chiefs of Ontario. And I'm speaking to you from Toronto, which I acknowledge is the traditional territory of the Anishinaabe, Haudenosaunee, and Huron-Wendat peoples. And I too would like to thank the elder for his remarks and his careful attention during this hearing. As you know, Justice, Chiefs of Ontario is an advocacy organization for the 133 First Nations in Ontario. And Chiefs of Ontario takes its directions from the leadership of those First Nations communities. And Chiefs of Ontario has been an intervener in these proceedings since 2009 to provide the perspective of the First Nations in Ontario. I'm here today to talk to you about the issues of identity, consultation, and consent in the context of the First Nations child decisions. These are the decisions at 2020 CHRT 20 and 2020 CHRT 36. And COU's submissions are grounded in a call for respect for the self-determination of First Nations in Ontario and the imperative that First Nations in Ontario and across the country be allowed to define for themselves who belongs to their communities and which children belong to their communities for the purposes of accessing Jordan's principal services. COU's submission is that this jurisdiction to determine citizenship for themselves, for First Nations to determine citizenship for themselves, is recognized in domestic law and policy and international law, and the tribunal's decisions which reflect consideration of those laws and those policies are reasonable. And those decisions are reasonable because they are animated themselves by the respect for self-determination and jurisdiction over citizenship. And in particular, the method by which the tribunal got to that final decision in 2020 CHRT 36, while it may be unusual, is similarly grounded in those principles of self-determination over citizenship. Now, for its part, Canada has submitted that the additional recognition of the two categories, if you will, of First Nations children as eligible to apply is an unreasonable decision. And Canada would rather confine the concept of First Nation citizenship to the Indian Act definition and to the other limited categories that it has already recognized. COU submits that this kind of approach is not in line with the preponderance of contemporary domestic and international law, and that the Indian Act definition is not setting the standard of reasonableness. It's not the standard by which we judge what is reasonable in this context. And in addition, we'll make some comments about Canada's submissions which use the language of consultation and consent about the content of these decisions and the process of these decisions, and the role that that ought to play when reviewing the reasonableness of the decisions. So my submissions will be in three parts. I will review the First Nations child decisions briefly, although my friends, I acknowledge and thank them for having done so quite exhaustively. I'll review the community recognition process in particular, that's at Annex A of 2020 CHRT 36. I'll make submissions about why those decisions are reasonable in COU's view. And I'll address Canada's submissions, and particularly the submissions that they've made about consultation and consent. So as you've heard already exhaustively from my friends, the decisions at issue order Canada to consider Jordan's principal applications from First Nations children who aren't registered under the Indian Act, commonly called status. I like to use the expression registration under the Act. They're not resident on reserve, or they're not otherwise entitled to the eligibility criteria that Canada has recognized. And the Caring Society, for its part, went to the tribunal for further clarification about whether the tribunal's orders about Jordan's principles should be available to all First Nations children, including the unregistered children of a registered parent and children not falling into the other categories, but nonetheless recognized by their First Nation as a part of a First Nation community. And at CHRT or 2020 CHRT 20, the tribunal ordered the parties it recognized that those children ought to be eligible, but what it then did is ask the parties to go and to negotiate and come up with an implementation process of the decision. And that consultation and negotiation resulted in the decision that we have at 2020 CHRT 36. So for the entitlement decisions, I want to be careful to point out that the first category, let's say the unregistered child of the parent who's registered under Section 6.2 of the Indian Act, that Indigenous Services Canada will have to consider that application under the tribunal's order without any further engagement from the parent's First Nation, without any need to revise or reconsider a First Nations custom election code, a First Nations membership list or membership law that may be done under inherent jurisdiction, and without any revision or amendment to the Indian Act. Now, First Nations do become involved in the implementation of Schedule A of the decision at CHRT 2020 CHRT 36 in the recognition process, which we'll call it. And that's at the COO compendium at tab 3, and in the interest of time, I won't take you through it line by line. But at Annex A there, it defines what the process is that Indigenous Services Canada needs to undertake in order to confirm the eligibility of a First Nations child pursuant to the community recognition process. So, as Mr. Witke, my friend, had pointed out, it says that there are processes for Indigenous Services Canada to seek consent to communicate with the First Nation, and then we'll communicate with the First Nation and get some documentation from the First Nation with respect to the recognition. But what it doesn't do, it doesn't compel the First Nation to do any of this. It allows the First Nation the choice of whether and how they will engage in a community recognition process. So contrary to Canada's submission, they're not obligating First Nations to do anything aside from provide some evidence of their recognition. And that evidence, even within the community recognition process at Annex A, provides for a variety of mechanisms by which the First Nation may confirm that a child is recognized by their community as being a member or a citizen. So there's no prescription in this order that First Nations must do anything. And I'll point out that Chiefs of Ontario was quite concerned that this might result in a prescription for First Nations that might be unreasonable at the tribunal, and the tribunal satisfied those concerns in the course of making this order. So now I'll turn to the reasonableness of the decisions, which my friends at the Caring Society covered quite exhaustively, and I'm going to sort of start at looking at the reasonableness, taking off from the fact that the tribunal had determined that the children were eligible for the most part. Once the eligibility is determined, what's the reasonableness of the process, which Canada is something Canada also takes issue with. There's a few submissions about the reasonableness of the substance, but so we're all agreed the standard of reasonableness is the one that is defined at Vavilov, And as we all know, it requires us to look at the chain of reasoning and look at the factual and legal context of the decision. And we adopt the Caring Society's submissions about the entitlement. But we do have some perspectives about the community recognition process. And so the community recognition process, as I said, does not require a First Nation to do anything in particular or anything at all to recognize children as part of their community outside of their First Nations band list under the Indian Act, their First Nations custom election code, their treaty list, etc. But if a First Nation chooses to, they are entitled to, under this order, make inquiries or do their own process and recognize that a child's a citizen and that they think that the child ought to be entitled to apply for Jordan's Principle funding. And so this decision, quite rightly, the tribunal recognized, gets quite close to the question of First Nations jurisdiction over citizenship. And indeed, the First Nations parties at the tribunal had raised concerns about skirting near this jurisdiction. And while it's clear that a decision about recognition for the purposes of Jordan's Principle doesn't have the effect of altering a First Nations membership, it doesn't have the effect of altering First Nations band list, it doesn't have the effect of altering the Indian Act, it does get quite close to the heart of the notion of who belongs and what's the identity of a First Nations person and what's the identity of a community member in a First Nations process and law. And I'll note that Grand Chief Abram, who is the social services portfolio holder at Chiefs of Ontario, had provided affidavit evidence about these kinds of concerns with the process, with the possibility of meeting Jordan's Principle timeframes, and with the prospect of dictating to First Nations how they must undertake the process or what kind of result they must reach. And that affidavit evidence is at tab 254 in volume 18. And to that affidavit, Grand Chief Abram also appended a variety of Chiefs of Ontario resolutions, in which the Chiefs of Assembly recognized, validated, and called for Canada to recognize their jurisdiction over citizenship, and some of which denunciated the strictures of the Indian Act. So after having decided that the children recognized by their community should meet a threshold eligibility to apply for Jordan's Principle, the tribunals then faced with the problem of how to craft an order to make that real. And my friend Mr. Frater said, the heart of the decision is who is a First Nations child and how do we determine that? And you'll remember also that my friend Mr. Frater talked about how various officials from Canada had undertaken at least some limited consultations to ask First Nations, well, what's the definition of a First Nations child? And Chiefs of Ontario says that that's precisely the point. There is no definition of First Nations child because that's a decision to be made by each First Nation across Canada. And the parties had urged the tribunal that they couldn't come to a definition for exactly that reason. And so in our view, and I'll go through it in a little bit of detail in a moment, the tribunal was very alive to the fact that there was a possibility that making a decision that was a one-size-fits-all approach to defining First Nations identity and citizenship was going to tread closely or even to the heart of First Nations rights and jurisdiction over their membership. And that reasoning and that consideration of the laws and policies that are within domestic and international law is embedded throughout 2020 CHR 220. And my friend Mr. Taylor gave you the paragraph references, and they're also in my factum. There's extensive reasoning and consideration of how to tackle this problem. And so the context and law that they considered includes international instruments, especially the United Nations Declaration on the Rights of Indigenous People. And now we have C15, which I understand is just awaiting royal assent, which is the law to have the UN Declaration gain expression within Canadian law. And I'll leave the detailed explanation of that to my friends at Amnesty. But there's also domestic legislation promulgated by both federal and provincial governments, which acknowledges that First Nations have the jurisdiction and authority to regulate and make laws and identify their own citizens. There's domestic policy in the inherent right policy, which is also provided for in our compendium, and there's the common law. So there's the Canadian legal landscape of First Nations identity and jurisdiction over that identity is much broader than just the Indian Act. And in fact, COO submits to you that the Indian Act is the aberration, it's the outlier in terms of what is the controlling question with respect to First Nations identity. And in our submission, the Indian Act is the past, and the things I'm going to talk to you about now is the present and future. And that's the thing that we need to, those are the things we need to be looking at when we're thinking about what is this question and how do we tackle these questions of who is a First Nations child for the purposes of Jordan's principle or otherwise, really. So a very good and recent example of this is Canada's own act about First Nations child welfare. So the Act respecting First Nations, Métis, and Inuit children, youth, and families does two things. One thing that it does is it imposes minimum standards on any service provider, First Nations or non-First Nation, who is providing services to an Indigenous child, First Nations, Inuit, or Métis child. And then it also allows and acknowledges that First Nations are allowed and permitted to make laws, and it acknowledges their jurisdiction over child and family services in respect of First Nations children. And what's notable about that legislation is that First Nations child is not defined in the definition section. Nor is child, nor is First Nation. And so COO submits to you that the reason for that is because the way the Act works in its preamble and the way the Act works throughout is it acknowledges the jurisdiction over children. It has in its preamble the UN Declaration, the Convention of the Rights of the Child, and it acknowledges that First Nations have jurisdiction to make laws about First Nations children as defined by First Nations, not as defined by the Indian Act. And indeed also the minimum standards which it imposes on all service providers, regardless of whether or not they're a First Nations agency or not, also doesn't follow the strictures of the Indian Act. And so when my friend Mr. Frater is saying, well, we're compelled to follow the Indian Act, there's a very clear example here that they are not. There's nothing in the Indian Act which says, and my friend hasn't pointed to any provision of it, that all governments at all times must follow this act with respect to anything regarding Indigenous peoples or peoples who have rights or are identified by Section 35 of the Act. And so COO puts to you and COO submits that there's no requirement. There's no requirement to follow the Indian Act. It is a choice. And to the extent that, I mean, I think we would also submit that it's not a choice in some respects because there's an acknowledgement of the jurisdiction in this very law, in the Act respecting First Nations, Inuit, and Métis children. So I'm going to leave you with another domestic example of legislation, which also allows First Nations to decide which children are their citizens. And that is in the Ontario Provincial Child Welfare Law, the Child, Youth, and Family Services Act. It also does not confine the definition of a First Nations child to that contained under the Indian Act. So it's at tab 7 of our compendium for your reference. That act also refers to the UN Declaration on the Rights of Indigenous People and the Convention on the Rights of Children. And it also provides First Nations the freedom to decide who a First Nations child is for the purposes of availing the nation of their rights under that act, for the purposes of defending the nation, going to court with respect to children. And the First Nation is able to decide who are its members, who it would like to acknowledge for the purposes of the act. Now, moving on, I had mentioned briefly at tab 12 of our compendium, we have the inherent right policy. So as you'll know, Justice, that's the policy under which Canada negotiates self-government agreements. And again, in that policy, there's an acknowledgement that citizenship or membership is a subject of discussion and something over which First Nations have jurisdiction when negotiating self-government agreements. And so in our view, that's yet another sort of domestic expression, if you will, of this jurisdiction. And lastly, my friend, Mr. Wookie, referred you to the Supreme Court case in Des Sautel and the paragraph 85, which is found at tab 9 of our compendium, which discusses that the content of Aboriginal peoples of Canada, or the content of who is a First Nation, is for First Nations to decide, pursuant to their own laws and traditions. And so that's the legal context under which the tribunal is making this decision. Having determined that there's an entitlement, the implementation of it is, I suppose, give a one-size-fits-all definition or do something else. And so in our submission, they did something else. And they took into account this landscape, federally and domestically, domestically and internationally, about First Nations jurisdiction. And that's precisely the right thing to do. And I'll refer you to tab 11 of our authorities, or our compendium, which is the Wasanich decision. And in Wasanich, it's a pre-Vavilov decision, we'll acknowledge, but it talks about the animating principles similar to Dore and the analysis that an administrative body needs to go through when they're making a decision that involves, in Dore, as you know, charter rights, and in Wasanich, Aboriginal rights. And the Federal Court of Appeal finds there that, just like in Dore, there should be no distinction when it's an Aboriginal right and not a charter right, and that the Administrative Tribunal needs to take into account the values that underlie the Aboriginal right when they're making a decision. And we'd submit to you that that's exactly what the Tribunal did when it put the implementation of the decision over to negotiation by the First Nations and Canada together, and then ultimately when it allowed the First Nations to make that decision for themselves through a process that the Tribunal chose not to define. And in our view, we'd submit that it's a reasonable decision because of that. So I'm going to, yeah.
Just a quick question. So
and no need to be quick.
Where is the connection, I guess, to, or the end, right? So there's a process to determine. So focusing back to this complaint and the decisions. So this process of determining who's a member, member or citizen.
Citizen, yeah.
So that is just, at some point, is there going to be a handoff so that, or is it going to become a new policy or a rule of law? Sorry, just in terms of where this ultimately ends up, because it's not going to be here for my lifetime, I'm assuming. There will be a way that it just kind of deals with itself. Can you, what are your thoughts on that?
So if I understand the question, and I'm going to ask you if I understand it. You're asking what happens after that determination is made within the nation, or what happens with respect to the child's eligibility for Jordan's principal purposes?
Just within the nation first. Okay, so that's...
Yeah, sure. I mean, I think that's it's an interesting question, and it's a good question. And I agree with you that I'm not sure that anything happens necessarily, right? I think it seems to me that what would happen is, the First Nation official that's identified pursuant to Annex A of 2020 CHRT 36, they sign off and say, Maggie Wenty's daughter is recognized by Serpent River First Nation for the purposes of Jordan's Principle. And then, so that's the one side, that's the administrative side. And what does Serpent River First Nation do with it after that? Well, I suppose they could say to themselves, you know what, it would be nifty if we had a custom membership code. Serpent River is a bad example because they do have a custom membership code, but it would be nifty if Serpent River had a custom membership code. Maybe we'll go that route under the Indian Act. Or maybe one day they'll have the recognized authority to determine their own membership, right? I mean, there's been talk, I guess, for some time by this government, certainly, that one day we're going to move into a world where there is no Indian Act, where we're moving into a world of First Nations jurisdiction and recognized jurisdiction over their membership. And so I think it's for the First Nation themselves, frankly, to decide what they're going to do with it. Are they going to file away the name of these people for a rainy day when they can acknowledge them as members fully and completely within the confines of the law? Are they going to say, well, that's just for service purposes, but we definitely want that child to have services? I mean, to me, I don't think there's a prescription about what any First Nation needs to do. I mean, and that's precisely the point, right? Is that a First Nation ought to be able to just sort of decide. And I mean, we're right now, as we've all acknowledged, in a situation in a time and place where First Nations don't have that control. And they don't have the ability to just say, well, I'm going to alter our membership list, because we all know it's not that easy. If they alter their membership list, even through a custom code, and the child isn't status, well, then they don't get funded for certain things for the child, right? And so, I think my answer, which I just said very, in a real wordy way, the short answer is TBD, right? To be determined.
Yeah. And just to follow up, I think, as just listening to what your answer was, is that it ultimately status, there's a money component, right, or a funding component, as you mentioned. So at some point, it still comes down to that at some point.
Sure. I mean, I don't have any evidence in this on the record, I don't think, but sure, if you have a child, I'll just tell you from my personal experience, and you'll do what you need to do with it. But, if you have a child who's living on reserve who, doesn't have status, but is a member, my understanding is that child, for instance, doesn't get, the First Nation doesn't get the education funding on behalf of that child because the child doesn't have status, even if they're recognized as a member under the code. But I stand to be corrected on that. But you're right in that ultimately, I think the stickiness of this problem is in part because we have this ongoing disconnect between what First Nations think they ought to be able to do and what some First Nations can do, right? Like those who have modern treaty agreements are allowed to define for themselves from the get-go what they're doing. But we have a real patchwork in this country about who's allowed to be a member of a First Nation in the eyes of Canada, right? Which is a different question than who's allowed to be a First Nation in the eyes of a First Nation. And this is the tension, ultimately, I think, that the tribunal is trying to resolve. And in our view, justly chose not to wade into. They chose not to give a definition. And I'm going to get to this because that's something that, that Canada, that uncertainty or that leaving it dangling was something that Canada thought was unreasonable. And so in a moment, I'm going to turn to that submission about why, how, in fact, I'll turn to it right now. Let's just go. So Canada says it's at its submissions, and I think it was at paragraph 54. I'm having a little trouble reading my writing there. That this failure to provide a definition or a failure to provide certainty and turning it over to the parties to negotiate how this process would roll out was an abdication of the tribunal's responsibility. And I really think that we need, and the court needs, to interrogate that notion, because who would submit that? So Canada says this can't possibly meet the Vavilov standard of reasonableness because they didn't make a decision. And what KU submits is what you need to do is go back to Vavilov, because the Supreme Court in Vavilov says context. Context is everything. And so saying this can't possibly meet the Vavilov standard rests on a presumption, we'd submit, that all administrative decisions in all contexts need to be made exactly the same way. And we say, when you're operating in a circumstance in which there are constitutionally protected rights at stake, in which there's inherent jurisdiction, in which there's rights that are protected and recognized under international law, that maybe it's time to do things a little bit differently, and that's what the tribunal did. And yes, it's unusual, but it's unusual times in terms of recognition of First Nations jurisdiction. So as I say, when we hearken back and look to the fact that Canada did just recognize First Nations jurisdiction over child and family services, my timer's telling me to stop, but I will not stop. That we did just recognize that jurisdiction. But as I say, there's a patchwork about how we do that. And I don't think that Vavilov, or the Supreme Court, is telling us through Vavilov, well, every administrative decision maker needs to be exactly the same in the way that they make decisions. In fact, I think Wasanich from the Federal Court of Appeal says, no, you have to take these things in mind. And what we have, and so we'd submit that Vavilov actually requires you to take into account not just the context that you have two different governments here, but also the preponderance of the law and the preponderance of Supreme Court jurisprudence going back to Haida that tells us over and over and over again, reconcile, negotiate, try to work it out. And so it's inconvenient. I get it. It's inconvenient for Canada to not have a one-size-fits-all definition, to not be able to go into their registry and look up a person and check a box when they're determining eligibility. But that is, in my submission, just sort of the messy business of this country, where we have different jurisdictions and we have Indigenous laws that are layered on top of federal and domestic law. And that's exactly the project that the court's asking us to engage in when it tells us over and over and over again to reconcile and to try to reconcile the Crown sovereignty with the pre-existence of Indigenous people and the continued existence of Indigenous legal orders, which are protected by Section 35. And so I don't think we'd submit this isn't contrary to Vavilov. This is actually the kind of creative thinking that Vavilov demands of us in these circumstances. All right, so I'm going to move on from that just to my last point, if you'll let me. And I know my friend Ms. Matthews said I could steal 5 minutes of her time, and I'm grateful to her for that. Let's talk about consultation and consent. Easy issue, right? We noted in our written submissions, we note that Canada's written submissions have several points in them in which they talk about, they use language about consultation and consent and how that relates to these decisions being issued. And interestingly, there are points in Canada's written submissions which say sometimes there was too much consultation. It's endless consultation that we're required to participate in as a result of these tribunal decisions. And curiously also, Canada makes a submission that there should have been consultation, or there needed to be consent or agreement from, at one point, I think Canada says individual First Nations about the content of the decision. And COO wants to take seriously the notion, a gesture of a commitment to consult and have consent from First Nations is always a welcome one. But Chiefs of Ontario wants to caution against sort of being tempted by these arguments that sort of arrive in a cloak of the language of consultation and consent. Because ultimately, Chiefs of Ontario thinks that this poses some problematic implications for access to justice. If we accept the proposition, as Canada has put forward or seems to have put forward, that there needs to be extensive discussions or direct consultations or agreement from First Nations before a decision can issue in a litigation, that leads to absurd results. It leads to results where First Nations will not be able to get remedies in court. It leads to results where Canada would be incentivized to either consult or not consult forever. If we said we needed that to occur before an adjudicative body could issue a decision. And if we're looking for all 630 plus First Nations in Canada to consent before a legal decision is made that affects them, well, then we're never getting there. And that's just, in our submission, ludicrous. You can't deprive First Nations of a remedy when they've come before a court to ask for one. So Canada said in its written submissions, and I alluded to this before, my friend Mr. Frater said they had asked First Nations for a definition of First Nations child. They went, in light of the tribunal's decisions, to look for this, and they didn't get their decision. And Chiefs of Ontario always welcomes further discussion with the treaty partners, with our treaty partners. And but in our submission, part of the reason why we got there is they asked the wrong question. The question wasn't how do you define who is a First Nations child for all, say, 133 First Nations in Ontario. We'll never get there. No, there's never going to be consent amongst everybody and agreement on one thing. They should have asked, how can we make sure that the children from your community are recognized in a way that you think is appropriate and just. So who really wants to say, don't be tempted. Don't be tempted by language that Canada is here to consult and here to seek the consent of First Nations, because that ultimately is something that's great for negotiations, but that can't be a prerequisite to a decision issuing in a litigation. And further, just practically speaking, on the record, it's not Canada's practice in this case to seek consent before it issues remedies. And for instance, before it makes its investments that it made after the initial merits decision, no consent was sought. And, I don't think the First Nations love that. But for Canada to pretend now that consent and consultation is something that ought to be a shield against a remedy, a shield against liability, is to us just not something that this court ought to accept. So I'm going to sum up now, and then I'll let my friend go because I've had my time. But in our view, the process adopted by the tribunal was reasonable, and it was the process that Vavilov demands, and it was the process demanded by the Federal Court of Appeal in Wasanich. You have to be looking at different ways of doing things, and it's not business as usual when there's inherent First Nations jurisdiction being touched on. And it's not business as usual when there's constitutional rights being touched on. And it is appropriate for the tribunal and reasonable for the tribunal to have adopted both a process and a result that involved First Nations and that did its very best to acknowledge First Nations jurisdiction over citizenship. And so for those reasons, we think and are asking this court to dismiss the judicial reviews. And so subject to any questions from you, Your Honor, those are my submissions.
Thank you, Ms. Whiteley. No, you've answered some of the questions that I was planning to ask, so thank you very much.
Miigwech.
That brings us to Nan and Ms. Matthews.
Thank you, Your Honor.
She didn't, Ms. Wente didn't eat into your time, I can assure you. You've got your previously allotted time back, so please begin.
Thank you, Your Honor. No concerns on my end. Just for the record, my name is Akosua Matthews and I'm counsel for Anishinaabe Nation, referred to as NAN. NAN supports the submissions made by the Caring Society, the AFN, and the Chiefs of Ontario in their entirety. At this stage, Your Honor, my submissions would have been entirely duplicative, which I'm loath to do on day 4 of a 5-day hearing. So I will not be making any additional submissions. Thank you, Your Honor.
Okay, I don't have any questions. Thank you, and we've the court has your submissions as well, so that's all well noted. So thank you, Ms. Matthews. All right, that brings us to the conclusion of day 4. So as far as tomorrow goes, thank you all for your submissions and for answering my questions. As far as tomorrow goes, we're looking at representations and submissions by Congress of Aboriginal Peoples, Amnesty International, the Human Rights Commission, and then the Attorney General of Canada's reply. We can figure out the agenda for whether it's going to lead to a lunch break before the AGC submits, or maybe we can get it all in the morning. We can deal with that in the morning. So I wish you all a good afternoon, and we will see you all again at 9:30 a.m. tomorrow morning.
Thank you, Justice Fable. Thank you, Counsel. The court is now in recess until tomorrow morning, 9:30. Thank you.